Magruder's American Government. Chapter 21, Civil Rights, Equal Justice Under Law. Section 3, Federal Civil Rights Laws. Those who, for one reason or another, oppose the enactment of civil rights legislation often rely on this observation: you can't legislate morality. That is, racism, sexism, and other forms of discrimination will not be eliminated by simply passing a law. The Reverend Dr. Martin Luther King Jr. responded to that contention this way: "Judicial decrees," he said, "may not change the heart, but they can restrain the heartless." Clearly, Congress has agreed with Dr. King, as it has enacted a number of civil rights laws over the past 40 years or so. Civil rights, Reconstruction to today. From the 1870s to the late 1950s, Congress did not pass a single piece of meaningful civil rights legislation. Several factors contributed to that fact. Among the major ones, through that period, the nation's predominantly white population was generally unaware of little concerned with the plight of African Americans, Native Americans, and other non-whites in this country. And Southern white Democrats, bolstered by such devices as the seniority system and the filibuster, had many of the most strategic posts in Congress. That historic logjam was finally broken in 1957, largely as the result of pressures brought to bear by the Civil Rights Movement led by Dr. King, see Chapter 6, Section 3. Beginning in that year, Congress passed a number of civil rights laws, notably the Civil Rights Act of 1957, 1960, 1964, and 1968, the Voting Rights Acts of 1965, 1970, 1975, 1982, and 2006, and Title IX in the Education Amendments of 1972. The Civil Rights Act of 1964. The 1964 law is the most far-reaching of those statutes. It was passed after the longest debate in the Senate history, 83 days, and only after the Senate invoked cloture, or limited debate, to kill a filibuster. Beyond its voting rights provisions, the 1964 law outlaws discrimination in a number of areas. With its several later amendments, the law's major sections now provide that no person may be denied access to or refused service in various public accommodations, hotels, motels, restaurants, theaters, and the like, because of race, color, religion, national origin, or physical disability, Title II. Prohibit discrimination against any person on the grounds of race, color, religion, national origin, sex, or physical disability in any program that receives any federal funding, Title VI. Forbid both employers and labor unions to discriminate against any person on grounds of race, color, religion, sex, physical disability, or age in job-related matters, Title VII. The Civil Rights Act of 1968. The Civil Rights Act of 1968 is often called the Open Housing Act. With minor exceptions, it forbids anyone to refuse to sell or rent a dwelling to any person on grounds of race, color, religion, national origin, sex, or disability. It also forbids refusal to sell or rent to a family with children. At first, the burden of enforcing the law fell on those persons who claimed to be victims of housing discrimination. They could seek damages from alleged offenders. Congress finally strengthened the law in 1988 to allow the Justice Department to bring criminal charges against those who violate its terms. Still, housing remains among the most segregated areas of American life today. Title IX. In Title IX of the Education Amendments of 1972, Congress added a key gender-based guarantee to the provisions of the Civil Rights Act of 1964. Title IX forbids discrimination on the basis of gender in any education program or activity receiving federal financial assistance. The statute intends to ensure that women receive equal treatment in all aspects of education. Its provisions apply to all schools, public and private, that receive federal funds, and nearly all of them do. Since its passage, Title IX has had its most telling effect on school athletic programs, especially at the college level, by requiring roughly equal funding and opportunities for women and men. The law has been in effect for nearly 4 decades now. Still, it continues to generate controversy. Affirmative action. These civil rights statutes all come down to this: discriminatory practices based on such factors as race, color, national origin, sex, or disability are illegal. But what about the effects of past discrimination? Consider an African American who, for no reason of his or her own making, did not get a decent education and so today cannot get a decent job. Of what real help to that person are all of those laws that make illegal today what was done years ago? So far, the federal government's chief answer to this troubling question has been a policy of affirmative action. That approach requires that most employers take positive steps, affirmative action, to remedy the effects of past discriminations. The policy applies to all agencies of the federal government, states and their local governments, and private employers who sell goods or services to any agency of the federal government. The federal government began to demand the adoption of affirmative action programs in 1965. To illustrate this policy, take the case of a company that does business with the federal government. It must adopt an affirmative action plan designed to make its workforce reflect the general makeup of the population in its locale. The plan must include steps to correct or prevent inequalities in such matters as pay, promotions, and fringe benefits. For many employers, this has meant that they must hire and or promote more workers with minority backgrounds and more females. The share of a group necessary to satisfy a particular affirmative action requirement, say the number of females in a company's workforce or the number of African Americans in a school student body, is often called a quota. Reverse discrimination. Affirmative action policies remain highly controversial today. This is principally because those policies necessarily involved race-based and or gender-based classifications. Critics argue that affirmative action programs amount to reverse discrimination, or discrimination against the majority group. Affirmative action demands that preference be given to females and or non-whites solely on the basis of race or sex. Critics say that the Constitution requires that all public policies be colorblind. The opponents of affirmative action have attacked the policy at the state and local levels in several places in recent years. Most often, they have relied primarily on the reverse discrimination argument as they have done so. In 1996, California voters gave overwhelming approval to a measure that eliminated nearly all affirmative action programs conducted by public agencies in that state. Since then, the voters in Washington in 1998, Michigan in 2004, and Nebraska in 2008 have adopted measures similar to California's. The Bakke case. The Supreme Court decided its first major affirmative action case, Regents of the University of California v. Bakke, in 1978. Alan Bakke, a white male, had been denied admission to the university's medical school at Davis. The school had set aside 16 of 100 seats in each year's entering class for non-white students. He sued the university, charging it with reverse discrimination and, so, a violation of the Equal Protection Clause. By a 5-4 majority, the court held that Bakke had been denied equal protection and should be admitted to the medical school. A differently composed 5-4 majority made the more far-reaching ruling in the case, however. Although the Constitution does not allow race to be used as the only factor in the making of affirmative action decisions, that majority of justices held that both the Constitution and the 1964 Civil Rights Act do allow its use as one among several factors in such admissions. Later cases. The Supreme Court has decided several affirmative action cases since Bakke. In some of them, it has upheld quotas, especially in such industries as construction, where long-standing discrimination was involved. The High Court has also held, however, that quotas can be used in only the most extreme situations. Thus, the court held in Richmond v. Croson, 1989, that the city of Richmond, Virginia, had not shown that its minority set-aside policy was justified by a record of past discrimination by the city. This approach has become steadily more apparent in recent affirmative action decisions. In 1995, for example, the court's decision in Adirond Constructors v. Pena marked a major departure from its previous rulings in such cases. Adirond arose when a white-owned Colorado company, Adirond Constructors Incorporated, challenged a federal affirmative action policy. Under that policy, the government gave bonuses to highway contractors if 10% or more of their construction work was subcontracted to socially and economically disadvantaged businesses, including those owned by racial minorities. Until Adirond, the court had regularly upheld affirmative action laws, regulations, and programs as mild but necessary restraints on behavior. In this case, however, the court held that henceforth all affirmative action cases will be reviewed under strict scrutiny. That is, affirmative action programs will be upheld only if it can be shown that they serve some compelling governmental interest. See page 619. The Constitution provides persons, not groups, wrote Justice Sandra Day O'Connor in the majority opinion. Protects persons, not groups, wrote Sandra Day O'Connor in the majority opinion. Whenever the government treats any person unequally because of his or her race, that person has suffered an injury, covered by the Constitution's guarantee of equal treatment. Affirmative action programs must be narrowly tailored to overcome specific cases of discrimination. The future of affirmative action. As controversy continued to rage over the place of affirmative action in the 21st century, the court's ruling in 2 Michigan cases signaled a continuation of the move away from this policy. The resolution of 2 cases, Gratz v. Bollinger and Grutter v. Bollinger, 2003, marked the High Court's most important statement on affirmative action since its decision in Bakke in 1978. The cases involved the admission policies of the University of Michigan. Jennifer Gratz applied for admission to the university as a freshman in 1997, and Barbara Grutter sought to enter the university's law school that same year. Both women are white, and both were rejected in favor of minority applicants with lower grade point averages and lower entry test scores. Both women sued the university. After losing in the lower courts, each appealed to the Supreme Court. In deciding the cases, a majority of the court found that the state of Michigan and all the states has a compelling interest in the diversity of the student bodies of its public educational institutions. That compelling interest justifies the narrowly tailored use of race as one factor in the student admissions policies of those institutions. However, Justice Sandra Day O'Connor, writing for the majority, predicted that affirmative action would become unnecessary in the coming years. We expect that 25 years from now, the use of racial preferences will no longer be necessary. A 2007 Supreme Court decision underscored this trend away from affirmative action. Parents Involved v. Seattle School District and Meredith v. Jefferson County Board of Education both centered on this question. To what extent can public school officials use race as a factor in assigning students to particular schools as they seek to maintain racially integrated student bodies? The court split 5-4 in the 2 cases. The majority found that the student assignment policies in both districts relied too heavily on race and also ran afoul of the 14th Amendment's Equal Protection Clause. In fact, 4 of the 5 justices in the majority favored the total elimination of race as a factor in school admissions decisions. It seems clear that the days of affirmative action programs are drawing to a close. That point was made again in Ricci v. DiStefano, 2009. In this case, a group of white and Hispanic firefighters sued the city of New Haven, Connecticut. They claimed that they had been the victims of reverse discrimination when the results of an exam were discarded after few minority firefighters qualified for a promotion. The court ruled 5-4 in favor of the firefighters. It said, in effect, that race could not be used as the sole factor in promotions.